the way that we've focused on privacy up to this point has been a focus on issues regarding procreation and marriage, which in the realm of gay rights and privacy makes it somewhat interesting because very clearly until recently, gay marriage was nothing that was, I mean, thought of by a broad swath of society. And so the rulings of, for example, Loving v. Virginia weren't thought of as going to be applicable to same-sex couples in the future up until really recently, the past 10, 15 years. And with regards to procreation, even the precedents there have to deal with contraception and abortion, which are issues that same-sex couples generally don't deal with. Issues of contraception between same-sex couples is usually not necessary, and abortion would rarely happen except in cases of assault or actual intentional pregnancy in which the life and safety of the mother were in place. And so rulings in these areas don't provide a significant amount of guidance to the court with regards to how to handle issues involving gay rights. We know from Stanley v. Georgia that individuals are considered, the home is considered a private entity, but it's not at all far sure how far that goes. And when we look to a particular class of laws, the guidance that was given to the court in terms of the legislatures passing laws was not at all clear, and they certainly, the legislatures of the time, were trying to regulate sexual behavior within homes. And what I'm speaking of is sodomy laws. Now, sodomy laws, by their nature as written, can apply equally to both same-sex couples and opposite-sex couples. Sodomy laws are usually, as written, broad enough to be equally applied to both classes. But overwhelmingly, they were written to apply almost exclusively to same-sex couples. What that means is, even if they're written in a way that doesn't invoke same-sex union, the laws were intended to persecute that same-sex union. And then in the example of states like Texas, the law was very clearly written to prohibit homosexual sodomy, whereas to allow same-sex sodomy as natural within one's home. And so the two general issues that arise with regards to these sodomy laws, first being the equal protection argument, that if these laws, like, for example, Texas's in name, treated same-sex individuals differently from opposite-sex individuals, then that might be an equal protection claim, because you have a law that is treating two different classes of people differently. And that, at least by interpretation of the 14th Amendment, a somewhat broader interpretation of the 14th Amendment, would be a violation of equal protection. But there's another segment of those sodomy laws that seems to be applicable, and that's the nature of privacy. And telling would be the majority opinion in Griswold, where we write, would we allow the police to search the sacred precincts of individuals' bedrooms for telltale signs of contraceptives, and all you have to do is put a big parenthesis out that homosexuality. And so Griswold sort of signals this idea that individuals' bedrooms are the height of privacy. And therefore we would expect that the precedent in Griswold might be very telling to future cases. Well, as it turns out, it was very difficult for individuals to get standing to challenge the legality of sodomy laws. For obvious reasons, many of these laws were exceedingly rarely prosecuted. Individuals are very rarely charged with violation of sodomy laws. Um, and in the conception of when they're charged with them, there were usually stacks of other charges as well. Um, because the most often prosecuted sodomy charges would involve a form of forcible rape or a form of sexual assault, and sodomy would be grouped along with those. But the nature of a same-sex union happening within private, it's a very difficult thing for first to observe and second to actually attempt to regulate. The first of those cases that we'll discuss is Bowers v. Hardwick that takes place in 1986. So Hardwick in this case is an adult male who was charged with violating Georgia's law against sodomy with another adult male in the bedroom of his own home. Now, one has to ask, how do the police observe and attempt to prosecute this fact? Well, the manner by which the cops got to the point to bring charges was that a police officer knocked on the front door of Bowers, and although there was no answer to the door was slightly ajar, so he simply pushed the door open and walked in to see if anyone was home, and found Hardwick in the bedroom having sex with another man. And just the police had their evidence, it was available to them, and Hardwick was charged with violating the anti-sodomy statute that existed in Georgia at the time. Now, the local district attorney used his discretion and simply declined to bring the matter before a grand jury, which ultimately means that Hardwick was not formally charged with the crime that criminalizes sodomy. But Hardwick still chose to bring suit in federal court against the state to have the statute declared unconstitutional. And the issue in this case is simply whether the anti-sodomy statute in question violates the fundamental privacy rights of homosexuals. This was a close decision. It might be shocking that this was a close decision in 1986, but it wasn't a slam dunk by any stretch of the imagination. This is a hotly debated issue. And in fact, if one small thing had changed, it actually probably would have been 5-4 the other way. But in this case, the court holds in a 5-4 decision that there is no fundamental right to homosexual privacy. And as a consequence, the law and other state laws like it were not unconstitutional. Writing for the majority, Justice White argues that accepting the decision in these cases, citing Roe, citing Griswold, we think it evident that none of the rights announced in those cases bears any resemblance to the claimed constitutional right of homosexuals to engage in acts of sodomy. No connection between familial, marriage, or procreation on one hand and homosexual activity on the other hand has been demonstrated. So for a majority in the court, all of those privacy rights announced, Griswold, Roe, etc., linked together the idea of family, procreation, and marriage. And in this case, despite the fact it was two privately consenting adults in the privacy of their own home, the privacy right did not extend that far. The Supreme Court continues to write that this issue has been traditionally handled by state legislatures. And they cited the evolution of law within the United States. In fact, they note that until 1960, all 50 states had criminalized sodomy to some degree. And at the time the case was decided, 25 states still did criminalize sodomy until at the time. And they say against this backdrop, to claim that a right to engage in such conduct is deeply rooted in this nation's history and tradition or implicit in the concept of ordered liberty is at best facetious. And so the court simply does not extend privacy rights to same-sex couples within the privacy of their own home. And so the court's simply not willing to invalidate these laws. Now, 4 judges concurred in that majority, agreed to that majority opinion. Justice Powell writes a concurrence, but concurs only in the judgment of the case. In essence, he's agreeing that there is no substantive due process right to cover homosexual behavior. But he doesn't agree in the majority's reasoning. We'll come back to discussing Justice Powell after we handle the dissents in this case. So Justice Blackmun, Justice Brennan, Justice Marshall, and Stevens all dissent. And they make an argument connecting Stanley v. Georgia to Roe, to Griswold, and say that very simply any kind of private consensual sexual activity, particularly within one's home, has to be protected as a fundamental right to privacy. Let's talk about Powell for a second. Powell concurs in the judgment, not in the majority's reasoning. And we know based on conference panels that have circulated that he was struggling with this decision. In fact, looking at how he voted in conference, he initially voted that he would strike down the law as unconstitutional. But after the opinion was circulated, he changed his mind. And by changing his vote, we get a 5-4 majority that strikes down, a 5-4 majority that was going to strike down the law becomes a 5-4 majority to uphold it. And so Powell's switch here is important because it renders the outcome of this case. Justice Powell indicated after he retired that if he had it all to do over again, he would have voted to strike down the law in Bowers v. Hardwick as unconstitutional. And the way that he gets there is upon his retirement. And most Supreme Court justices do this, but upon their retirement, they invite all of their former law clerks back and they have sort of a retirement party with all of their former law clerks there. And in the process of having this retirement party, one of his former law clerks asked him, well, Justice Powell, why did you decide the case that way? You're a defender of individual rights. You've always been on the side of privacy. You've extended privacy rights where they needed to go. Why did you decide the case in that way? And Justice Powell said, well, I don't think the effect of that case is actually that broad because I think in my life, and I don't know any homosexuals. And the clerk was very much taken aback because the clerk then in the next breath tells him, well, Justice Powell, you've known a homosexual for near 10 years. I'm homosexual, Justice Powell. And that is when Justice Powell decided to hold basically a press conference and inform everyone that he thinks he wrongly decided this case and would have switched his vote. And so I tell the story not to make light of the fact that this case was could so easily have gone another way, but to demonstrate that there are a lot of things that go on to affect the individual choice of judges in any given case. And they can very, very easily change their mind and change their mind over time. We oftentimes like to think that the law is the law and that judges, as Chief Justice Robertson said, merely call balls and strikes. But that's not the case. And we've seen throughout the time of this class that judges, even on the same issue, can change their opinion over time. And here's very particularly a case where Justice Powell, had he had more information, would have made a decision to strike down the law in Bowers v. Hardwick, but he didn't. And that also, to a degree, shows the humanness and the frailty and the failings of many of these Supreme Court justices. And it's always important to remember that these individuals are human, and many times they make their decisions like any other human, and that's based on information that they have readily available at the time, and sometimes that information fails them. And in this case, Justice Powell went on to say that this decision in this case, the outcome of this case, was one of his biggest regrets, and that he wishes and wished at the time that he could change it, but he couldn't. And that's kind of important because this change, the leaving of this law is constitutional, um, means that states were able to continue on with these laws and did so until 2003. When the next case that we finally discuss, the Supreme Court strikes down sodomy laws. Um, but that was a long time coming from a decision that Justice Powell might have made, and in fact believed that he should have made in 1986.